on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area.
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer. I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. Good luck to you.
We're about to go to war.
This court hearing escalates quickly as Judge Urich, who doesn't tolerate nonsense, takes on a sovereign citizen who's either pretending to be crazy or genuinely out of touch with reality. The defendant is facing 2 counts of public indecency after being caught engaging in inappropriate behavior at a park, yet instead of addressing the charges, he dives into absurd legal arguments that have no basis in reality. Judge Urich remains composed, shutting down his nonsense with pure legal facts, but the defendant's bizarre behavior makes it hard to tell whether he actually believes what he's saying or is just putting on an act to avoid responsibility. His confidence in his delusions is almost comical, yet the situation itself is serious, and the judge refuses to let him derail the proceedings. As the case unfolds, it becomes a wild clash between logic and nonsense, making for a courtroom moment that's equal parts frustrating and fascinating. Do you think he's truly out of his mind or just playing dumb? Let me know in the comments, and if you enjoy content like this, don't forget to like and subscribe. Now, let's dive in.
Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today.
He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying assault from 2019 out of Markwood Woods, which looks like it was deferred up as assaulting a public officer or obstructing.
Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Given everything that's before the court at this time, the court will set bond in the amount of $50,000, cash or surety, no 10% allowed at this time.
I have to say, Judge Urich is truly skilled at handling these sovereign citizen cases. I've seen other judges either lose their patience or waste endless time arguing, but he shuts down the nonsense fast. The way he points out the contradictions in their arguments is honestly hilarious. He has this subtle but effective way of dismantling their claims without getting worked up. And let's be real, the $50,000 bond was a solid decision. This guy already has multiple felony charges at a young age, and the last thing he needs is to be back out on the streets. Hopefully, he can turn things around. But honestly, I have no idea if he's genuinely struggling with mental illness or just putting on an act. What do you guys think? Let's get back into it.
If Mr. Stringer wishes to bring various motions before the examining judge, and that could include a motion to modify his bond, that is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on what is going on? Right?
I'm sorry, sir?
I'm being charged. I'm being charged an entity that is.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
I don't know if you guys caught that, but he literally just said, "We're about to go to war." That has to be one of the dumbest things I've ever heard someone say to a judge. If I were the judge, I would have hit him with contempt immediately. But now, we're about to dive into his second hearing. And this time, he's in front of a different judge who does not hold back. Things get super heated in this one, and it's definitely a wild ride. Let me know what you thought about the first hearing, and let's jump into the second one.
Mr. Stringer, state your name.
I don't acknowledge myself as Derek Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
A living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mott-Lewis, can you prepare an order for competency review?
Do you think this judge is making the right call by ordering a competency review for the defendant? If you're not familiar, when a defendant tries to fire their attorney, it can create major issues for the court, especially if they are mentally incompetent. Without legal representation, they can't properly defend themselves, which can lead to delays, complications, and even potential violations of their right to a fair trial, possibly resulting in their charges being dismissed altogether. Even though this guy believes he's some kind of legal genius, it's pretty clear he's struggling with mental illness, and his inability to understand the legal process just slows everything down. A trial requires a basic grasp of the charges and proceedings, and without that, it's like trying to play chess without knowing the rules. Pure chaos. This review is crucial to determining whether he can actually stand trial or if further intervention is needed. What do you guys think? Is the judge making the right move, or should they handle this differently? Let's get back into it.
I'm going to wait to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sanutko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request
What label, excuse me,
for
what,
a competency evaluation?
what labels me incompetent? My intelligence, because I have a high IQ?
No, that's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability
I oversee the nature of the proceedings. It's the fact
that you have the ability to assist your attorney
that
in your defense.
to withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father, and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number, and he did not do that. So I would like him to withdraw from my case, sir. I have no. So he isn't competent enough for me, honestly.
I'm almost certain this competency review will confirm that this guy is mentally ill. He's already racked up so many felonies, and at this point, it feels like it's just going to keep happening. Don't get me wrong, I'm all for giving people second chances, but he's burned through an entire stack of them. The real question is whether he's actually dealing with mental illness or if he's just another sovereign citizen who thinks he's above the law. The fact that he was caught engaging in indecent behavior in public makes me lean toward him having some serious issues. What do you guys think? Did the judges handle this the right way? Personally, I think they did everything they could. Maybe if they had held him in contempt, it would have forced him to change his attitude. But who knows? Let me know your thoughts in the comments, and if you enjoy content like this, don't forget to like and subscribe. Thanks for watching, and take care.